Proposition 19 went into effect February 16, 2021, and there are other provisions, but I'm really just mainly going to be focusing on how it changed the parent-child exclusion. What that is before, it was a lot easier to transfer real property to children without the real property taxes being reassessed to the fair market value. Now, with Proposition 19, that's going to be a lot more challenging to do. And the Alameda County Assessor's website is a great resource. They have sort of a little table and frequently asked questions, and they also have a wonderful webinar, and they also have a tax calculator, so you can kind of get an idea of what the reassessed taxes will look like, which can be several $1,000s more a year, depending on what the current assessed value is, and then if it's a change of ownership, gets reassessed to the fair market value. So for some people, it means their children can't keep the house, that they can't afford to keep the house. So it's pretty substantial for some families, and things that families tried to do to avoid being caught up by this, and not everyone was able to do something or did do something. So this is the Alameda County Assessor's website, and I will provide this link and also a link to the tax calculator. Basically, the big things to take away from Proposition 19 is the requirements now for parent-child exclusion from reassessment of property taxes is going to be, one, it has to be the parent's primary residence. So if, for example, it's a second home or a vacation home, it will not be eligible for the parent-child exclusion. And when the transfer is made to a child, the property taxes will get reassessed to the fair market value, regardless of, if the parents have a base assessed value of 40,000, if it's now, 500,000, the whole thing is going to get reassessed, and there'll be a substantial increase in property taxes. So must be the parent's primary residence. That's the first point. The second point is it has to be the child's primary residence. So in order for that child to receive the parent-child exclusion from reassessment of property taxes, they have to live there. They do have a year from the date of transfer to live there. So for example, a parent passes away after the proposition went into effect, which was February 16th, 2021, then that child has a year from that date, the date of death, to file a homeowner's exemption with the assessor's office. And they sign it under penalty of perjury that that is their primary residence. So in calling the assessor's office, I have some contacts there at Alameda County Assessor's Office. They have told me that the Board of Equalization, which is where they get their instructions from, have not told them that they need any additional supporting documentation that it's a primary residence of the child. So they don't need like utility bills or anything like that. They just need the child to file a homeowner's exemption with the assessor's office, and that just has to be done within a year from the transfer, whether the transfer is the date of death, or if after February 16th, a parent transfers an interest or the entire property to a child, then they have a year from that transfer to file the homeowner's exemption. The third big point of Proposition 19 with regard to the parent-child exclusion is there's now a ceiling, a dollar limit on the amount of the exclusion. Now it's the parents' assessed value on their property. So on the parents' property tax bill, if it says their tax base is calculated on, $500,000, then they get to exclude, the child gets to exclude from reassessment that 500,000 base tax assessed value plus $1 million. And that's it. So if the property is appreciated more than the base tax value, if it's 500,000 plus a million, if that property's worth 2 million, when it's transferred, then 500,000 of that is going to get reassessed by the assessor's office. And that would be a substantial increase. So, and Proposition 19 was passed in November 2020, and it passed by 51%. And I think that a lot of people maybe voted for it because the other provisions of it are for seniors. I don't really consider 55 and older senior, but seniors, disabled, and fire victims. So the other provisions of Proposition 19 that I'm not really going to go into too much are that if you're 55 and older and you move and buy another house, you're going to get to transfer your prior property tax basis. Even if you're buying a house for substantially more, your tax basis isn't going to be what you bought the house for. It's going to be your prior house. And I think you have a limited time period to transfer that tax base. And then I don't know if any of you saw television commercials or heard on the radio about Proposition 19, but they had a woman saying, "Oh, I wanted to be closer to my grandchildren, so I sold my house and I bought a new house, but the new house, the property taxes were so much." And so I think that's maybe why a lot of people voted for it. And also victims of fire, if they're forced to buy another house, their prior house tax basis, they get to keep that, their property tax basis. So I think that might be how it got through. There's been some talk about it going back on the ballot and going away, but we don't know what's going to happen with Proposition 19. And even if it does go away, whether it will retroactively, help people that have been caught up in it after February 16th. Let's see, and I'm going to go through. So this is, again, on the website. I've got two mice here, so let me go to the right mouse. So Proposition 19, it kind of goes into the history a little bit about the prior propositions, and then so Proposition 58 and Proposition 193, those were the old parent-child transfer and grandparent to grandchild transfer exclusions. Proposition 19 had no effect on the grandparent-grandchild exclusion. And for the grandparent-grandchild exclusion to apply anyways, the child in the middle has to be deceased. For example, if a grandmother wants to transfer an interest or an entire property to a grandchild, it's not subject to those other Proposition 19 restrictions. It wasn't really affected by Proposition 19, but in order for a grandmother to, let's say, transfer to a granddaughter, then that grandparent's child has to be deceased. So without that, then it doesn't apply anyways. I don't often find that that's the case. And then even if the child has passed away, there's an additional requirement that their spouse, which could be, daughter-in-law or son-in-law, not necessarily a biological child, they either also have to be deceased for the grandparent-grandchild exclusion to apply, or they have to be remarried. So it gets a little more complicated. Like I said, that's a side issue. If you have some of these assessment issues come up, feel free to call or email me. And there's specific forms for each one of these: a parent-child exclusion form, a grandparent-grandchild exclusion form, transfer if you're 55 or older of your tax basis, and if you're disabled. So different forms for all of those. And the parent-child exclusion form that we currently have is old. The new one for Proposition 19 hasn't come out yet. So even though it's been in effect since February 16th, we don't have a new form from the Board of Equalization yet. So I don't know if for transfers that I'm recording for clients after February 16th, if I'm going to get a letter where we have to resubmit a new parent-child exclusion form. So anyways, I'm going to go to this little table here. This is a little summary of some of what we talked about the parent-child and grandparent-grandchild exclusion. Um, so you can see for the grandparent-grandchild exclusion here, there really isn't a change here. So I'm mostly just talking about the parent-child exclusion. So it talks about the limits. This current law is not the current law anymore. Proposition 19 is the current law. So you can look at that. That's a summary of kind of what we were talking about. Um, Here it talks about the Proposition 19 deadline, which has already passed. It was February 16th, 2021. So any document that was not stamped by the recorder's office until after, February 16th or February 16th, then they would be subject to this new Proposition 19. And here it talks a bit about persons at least age 55 or disabled persons and about those changes. And I'm not going to focus so much on that because I find, for me anyways, most of my clients, I got calls before February 16th where they were trying to figure out how they could transfer property to a child now, particularly before February 16th. If they had a vacation property, they wanted to transfer it and say, well, I don't want this property to be reassessed. It's been in the family for generations. None of the kids live there. It's not our primary residence, but we want to avoid the property taxes on the being reassessed when we pass away. And then obviously for people that have multiple real properties, if they have like a rental property business or an apartment complex, or they also have commercial property, for people that own a lot of property, they already might be looking at something like, an LLC or an S corporation or a C corporation to try to protect those properties from reassessment that could occur through Proposition 19. The issue with transferring property to a child now, or now being after February 16th, transferring property into an LLC, S Corp, or C Corp, or even if you put the property into an irrevocable trust. So putting property into an irrevocable trust or some sort of business like an entity, that those are discussed as ways to try to get around this Proposition 19. The problem with transferring all the assets into a business entity or an irrevocable trust is the tax basis, the federal tax basis or California state tax basis. So that's different than the real property tax basis. So for example, when someone passes away, and that real property transfers to a child, that child receives what's called a step up in tax basis. So instead of it being what the parent paid for the real property, it's actually the dated death value. And that can be really significant if it's highly appreciating property. When it sells, it's not going to result in high, what's called capital gains taxes. So for example, if a property was purchased for $40,000 and then it's inherited by a child and it's worth 1.5 million, and that child turns around and sells it, the child's not going to pay capital gains taxes on the difference between the 40,000 that the parent bought it for and the new value of 1.5 million. Their value is 1.5 million, the dated death value, and then they sell it for 1.5. They pay no capital gains taxes, and then they'll have some deductions. They'll actually be able to claim some deductions. If you transfer property to an LLC, like I said, a business entity, or you put it in a revocable trust, it's going to be whatever the value is when it's transferred into those entities. So then if over 10 years it appreciates in value and then it goes to the kids, they're going to be paying taxes on the date it was transferred into those entities and then when they sell it. So you can't get your cake and eat it too. You can't get no reassessment of property taxes and no capital gains taxes later on when you sell it. If the numbers all work out and potentially, but it's going to be difficult to do that. And certainly setting up an irrevocable trust or setting up a business entity to try to avoid Proposition 19, that's expensive to do that, particularly a business entity. You've got annual filings, annual fees, potentially having to file additional tax returns. But I have some people that really, they really want to do this. And the big question for them is, if your child is going to turn around and sell this property after you pass away, it doesn't make any sense to do all of these things to try to avoid reassessment, because they're just going to turn around and sell it. So that's an important question when people are looking at, do I need to be concerned about property taxes? But I understand that it's hard for parents to talk to kids about that, but also the kids are like, I don't know whether I'll want this house 20 plus years from now, or whether I'll want to sell it. I don't know where I'll be living. Maybe they're still in school, like in college or something, and they don't even have their career figured out yet. Property tax calculator. This is also on the Alameda County Assessor's website. And this is just to give you an idea about how the supplemental taxes are calculated. And it's not, I don't think it's the best calculator, but anyway, it gives you an idea. So, and the reason they want to know a purchase date, and they won't let you put a purchase date in that's later than 12/31/20. So we're probably at some point going to have to update this, but this is really just for purposes of just giving you an idea. And the reason the month is important is because there's a factor that they use for calculating the reassessed taxes, or the supplemental tax bill, which is what a child would get. They inherit property from a parent after February 16th. And if they don't meet all the requirements of Proposition 19, it's not the parent's primary residence, it's not their primary residence, or the value is above that, assessed value plus $1 million, and there's a partial reassessment, the child's going to get a property tax bill that's called a supplemental tax bill. And that bill they'll receive in the mail, and they have 60 days to appeal it. So if the child says, oh, I disagree with this, I don't think this is correct, or I think that they're overvaluing the property, then you have 60 days to appeal it. You can do an informal appeal by calling the assessor, or you could do a formal appeal, and then you actually have a hearing before three panel person at the assessor's office. So anyways, so here's the tax calculator, and I just put in the last date that they'll allow you to put in. So I put 12/31/20, and then I put the purchase price of the property, just for making it easier for calculating. I just put in $1 million, and then I go next, and then I'm just putting that the current assessed value of the property, which would be the property on the tax bill, is 500,000. And then I put get estimate. And you can see up here, depending on the month, they have a pro rata factor. And so you can see why it's helpful to have this calculator. So at the end, they show their multiplied tax rate, and then they have a factor, pro rata factor, that they use depending on the month. And it shows you that the supplemental tax estimate is going to be an additional $3,000. But you can imagine if, let's say, the property is worth $1 million currently, and the assessed value is a lot smaller. Let's say it's 100,000. Let's see if it'll let me do this. Start over. 31. And then let's put $1 million. Let's see. 1, 2, 3. Okay. Let's see. Next. And then we'll put 100,000. Okay. Get estimate. So that's a $5,400 increase. Um, so for, let's say, a second home that children inherit from a parent, the entire property is going to get reassessed. So, for example, if the parent's assessed value is pretty low and the fair market value is really high, the property taxes may be so high that the children can't keep it. They can't afford to keep it. Um, or if they don't qualify for the parent-child exclusion because it's not the parent's primary residence, like I said, another home, or maybe the parents were living in there, but now they're in a nursing home, so it's not their primary residence anymore. Or the child doesn't live there, maybe they live out of state, so they're not going to file a homeowner's exemption. So it can be pretty significant, this Proposition 19, as far as what families will be able to do and afford with these properties.